With a historic constitutional ruling, taking a shot to President Trump's re-election bid.
Yeah, thanks for waking up with us, everybody. In a 4-3 decision, the Colorado Supreme Court declaring the former president is now ineligible for the highest office because he violated the Constitution on January 6, 2021. Those justices citing Section 3 of the 14th Amendment, which says this: no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same. Tom Dempsey is live in Washington with the swift reaction from the Trump campaign. Tom, good morning.
Good morning, Markie. Yeah, this morning, the Trump campaign team says it will file an appeal to this 4-3 decision from the Colorado Supreme Court, disqualifying Mr. Trump from appearing on the state's the primary ballot and declaring him ineligible for the White House. Now, it's interesting to note, Mr. Trump did not comment directly on this ruling, but right here on NewsNation, we spoke directly with former 2016 campaign manager Corey Lewandowski about this case. Take a listen.
The U.S. Supreme Court has to take this up immediately. The Colorado Supreme Court has put their decision on hold until January 4th to give the U.S. Supreme Court time. But what's amazing to me, Leland, here is Donald Trump has never been charged with an insurrection. He's never been on trial. He's never been even accused by Jack Smith, someone who has all of the resources of the federal government to go after Donald Trump. He's never been accused, charged, or convicted of this. So for the Supreme Court to rule in a 4-3 decision that Donald Trump is ineligible to be on the Colorado ballot only is going to drive this issue further.
This whole case in Colorado revolved around a lawsuit filed by 6 Republican and independent voters and whether or not the former president took part in an insurrection on January 6th. In this tight decision, the Colorado Supreme Court cited a provision in the Constitution dating all the way back to 1868, meant to prevent former Confederates or people who took part in an insurrection from holding office. In the court's majority decision, the state justices wrote, quote, "We do not reach these conclusions lightly. We are mindful of the magnitude and weight of the questions now before us. We are likewise mindful of our solemn duty to apply the law without fear or favor and without being swayed by public reaction to the decisions that the law mandates we reach." A big focus now will be on whether or not the Supreme Court decides to take an appeal to this case. Other states dealt with similar cases to the one in Colorado. In fact, in Minnesota, the state Supreme Court dismissed a lawsuit there and said anyone can be on a ballot, while in Michigan, a judge said Congress should be the ones to decide if former President Trump can stay on the ballot. And expect a very quick timeline with this moving forward because the Colorado election officers will be printing primary ballots in a little over 2 weeks. Guys?
Tom, thank you very much. Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.